Okay, and then I have the ability to record, so we're recording right now. I'm going to stop recording. Okay.
And Jennifer for coordinating this along with Sherry. There's a lot of logistics that go on behind the scenes here. Despite it's all virtual, there's still a lot of legwork the office has to do to get these things up and running. So thank you to our presenter and our staff. Really appreciate all the work you did and are doing, especially in this time with COVID-19. It seems like the new normal is a lot of social distancing and virtual meetings. And I think it's only been a couple of weeks, and it feels like it's been a couple of months at this point. So we say to everybody, we're all in this together. We're all with you on that. And one of the things we're doing as a chapter is still delivering value to the members out there. And this is just one of many of those sort of services we're looking to pivot and provide in a new virtual world for now to make sure that you've got the information you need as soon as we get it and we verify that it's accurate in this day and age. I think that's important. So right now, it looks like there's some opportunity for those that are uncertain what's going on. Just real quick, Vermont is shut down for all but essential construction work. We've heard from the governor that he's likely going to be extending his executive order on that past April 14. He doesn't know when or for how long, but looking at other states, I would not be surprised if he doesn't into early May at the minimum. New Hampshire is still working, but some talk about just making sure we follow PPE standard guidelines from OSHA and the CDC, social distancing and wiping down of surfaces kind of thing. Massachusetts, you could still work pretty much everywhere. There's some conflicting stuff that's come out from a couple of municipalities, but regardless, the state there has preferred some mandates, I guess you could call them, to follow for every contractor and every job site. And, we're monitoring that stuff to see how it happens there and how it may come into New Hampshire's perhaps suggested guidelines. So long story short, in New Hampshire and Massachusetts, you could still work, but, use common sense, follow those guidelines preferred by OSHA, of course. As a chapter, as we continue to get through this, we will continue to update everybody, providing the most accurate information when we get it and deliver it to you in a timely fashion. So I thank everyone for turning to ABC as a resource on this. We will continue to service in that function and as well as more. We're already thinking ahead to the summer here for some of our exciting events. And I will tell you, we as a staff are excited, just as excited as you are, to get back together and celebrate our fellowship in the merit shop philosophy and just kind of return things to normal. But until then, again, please call, text, email Jennifer, Sherry, myself. We're happy and here to help you out. So wonderful. I guess with that, I'll turn it back over. Thank you, Jennifer, for the chance. And Ron, thanks again for today's presentation.
You bet, Josh.
Thank you, Josh. We did have one question come up on chat, and somebody's asking if we're sure about Massachusetts. That may have changed a little yesterday afternoon.
I'll be covering that, Jennifer, in my presentation.
That's what I figured. Yeah, I needed to update on that. And then, so again, somebody else asking about Massachusetts. So Ron will get to that during his presentation.
We will be discussing that, yes.
Yep, great. So I'm going to go ahead and take my image off here, and then Ron, as I have questions coming up, I'll go ahead and pop up and we'll get this thing going. So it's all your show. Thanks.
Thanks so much, Jennifer. I appreciate everybody this morning who have logged in or called in for this presentation and in this virtual way invited me into your homes, and I guess in that same virtual way, welcome to mine. It's obviously as Josh just put it, a very different norm right now, which is interesting to an industry that is not used to different norms, frankly, because of the fact that we sort of build the way we build and have been for many, many years, other than some changes in delivery methods and processes, et cetera. But the fact of the matter is we're in a different time, an unprecedented time. In fact, my wife this morning asked me if I was going to start with an April Fool's joke, and I said, I kind of think we're in one. It's a really, really interesting time that we're in. We, as I've always put it, you guys are out there basically trying to control chaos in a chaotic environment with a schedule that's completely inappropriate for the work, with working for owners who are have unreasonable expectations. And unfortunately, now we are we're also into an era that whereby you're not only working in a chaotic environment, you're in a chaotic environment within an ever-changing chaotic society. So it makes it even more difficult right now. And what I mean by that is clearly, as you guys know, you have to figure out nowadays whether you can work or not, which is just what Josh was talking about. The first thing you need to do when you wake up every morning is, can we continue to work on project sites that we were working, or can we start working on project sites that up and through yesterday we couldn't? And by that, we need to look at what as what we've all become commonplace with is shelter in place or shelter at home orders through the various states. And when we're talking about that, we need to understand that you need to look at not only the state, but the locality and the county, depending on what state you're in, what area you're in. And under those, obviously, a shelter in place order is what it is. It means you need to shelter in place. However, in every one of these, there are exceptions for what they call either essential businesses or essential services or essential activities. And so you have to make a determination every day in that state whether or not your business is an essential business or service or activity. And so one of the things that you have to do, besides thinking about whether you are, but is your subcontractors, are your suppliers essential? And where are your suppliers or manufacturers or distributors located? And whether or not they're in a state that they can't continue their business because they are not looked at as essential or an essential business, service, or activity. And because that is going to impact you, even if you are in a state that you can continue your work. Also, if you're in a state that continues the work, but the locality does not, some of the issues that you're going to have to address is not only can I work or will I work, but even if I do, even if I follow the state order, does the local order stop any permitting or anything like that? So we're going to get into some of those issues as we move forward. But these are all issues that you're now in this new norm going to have to understand and look at. And I do mean on a daily basis, because one of the things that you have to understand is these things are changing, and they are changing not by the week or month, but by the day and hour. I will tell you that as I put this presentation together, I was changing it up till last night with new information. And that wasn't a shocker, because I think I have changed this presentation on a daily basis, and I'm not joking about that. On a daily basis, I've made changes to this based on the information we're getting. As somebody put it the other day, it's the old adage of basically trying to drink out of a fire hose. Because of the amount of information we're getting on a sort of hour by hour basis from different states, from different localities, from owners deciding to close down businesses, from owners who are interpreting ambiguous laws that in a different manner than we are. We're finding out that workers on sites are testing positive or showing symptoms, and how that needs to be taken care of. So there's lots of things going on a sort of minute by minute basis. So getting back to the exceptions, if your business in this industry, obviously construction, which is all I do, if construction in that state is looked at as an essential business or service or activity, then you have to look at whether or not there's locality change. And what I mean by that is where in Massachusetts, for instance, where at least originally Massachusetts was very broad in their definition of construction under an essential activity, the cities of Boston and Cambridge were not. And then it became an issue of preemption. Whose order takes precedence? And that is going to be an issue that we're going to continue to deal with, that we're going to continue to deal with on a state-by-state basis. because we're going to continue to see more of those conflicting type of orders. But if your business is an essential business, if you have interpreted either the state or local order or both to provide you with the ability to continue to work in that jurisdiction, then one of the things you need to do is create some cards for your employees to carry with them that discuss the fact that they work for your company and that your company is providing what has been determined as a essential business, service, or activity, depending on how they classify it in that state. And that, and what we're recommending is that you put right in there where in the order or what the essential activity is and how it's defined within the order. Because that way, if your employee is pulled over by the police because he is not following the shelter-in-place order, he can show the officer why he's out in the essential business that he is attempting to carry on. So it's very important for them to have that. We've had issues whereby employees were pulled over without anything like that, and they weren't able to get to the job site. They created some significant issues. We have not seen anybody thus far, so that you guys know, either fined or arrested, but we want to continue to monitor that. So within each state, I'm going to start with New Hampshire because this is an ABC New Hampshire Vermont chapter presentation. I know we do have some people outside of that area, but I want to start with those. We have to look at what the governmental orders are in that area. In New Hampshire, Governor Sununu has put in a stay-at-home order that's in effect through May 4th, as Josh just talked about. Construction is designated as an essential business, and the fact of the matter is Governor Sununu has put in one of the most pro-construction orders so far, in the fact that he is allowing construction to progress without a lot of definitional exceptions. He's just asking that contractors be advised to follow OSHA and CDC guidelines. The state agencies in New Hampshire are continuing to determine how to ensure proper protection of workers on job sites and what they're going to do. I was intimately involved with the New Hampshire Department of Transportation's guidelines that should be out today. They were actually, I was told they were coming out yesterday. We do have a copy of what is coming out, but the copy I have is not signed yet by the commissioner. And so I do not want to have that sent yet, but it's very much a positive for New Hampshire in the fact that it is not a mandate like we'll be talking about with Massachusetts. The state of Vermont went in a very different direction. Theirs is a much more strict order that's in effect right now through April 15th. We do expect, as Josh said, the governor to extend that. But as of yet, we have not seen that extension. And he has basically closed everything but emergency construction in COVID-19 related to recovery. And so really the only exemption you have is if you're doing emergency service calls or, excuse me, healthcare construction related to COVID-19. The interesting part of this, when this came out, one of the discussions we had, and by the way, if you haven't been on them, the ABC has put on some very good phone calls whereby you can call in and discuss COVID-related issues. And I think Josh has been running that on a couple of times a week. One of the questions that came up during a recent one is whether or not, if you were a resident in Vermont, could you drive to New Hampshire if you were working either on a New Hampshire jobs project site or working for a New Hampshire construction company? The answer was no. The Vermont governor clarified that by a recent clarification put out that if you are a resident or non-resident, if you leave the state and come back into the state, you have to self-isolate for 14 days. So you will not be driving in and out of the state on a daily basis for work to a project site. Because once you leave, once you come back in, it's a 14-day isolation. So Vermont, very, very strict. Construction is going to be very difficult to carry on unless you're in one of those very specific areas. In Massachusetts, construction, as you can see from my PowerPoint, I said was generally designated as an essential activity by the state. However, as you guys probably already know and heard, Boston and Cambridge had shut down basically most construction projects, except for a couple of very specific exceptions, very similar to Vermont. Then what ended up happening is the governor came out, governor of Massachusetts came out and said that his order preempted the local orders, which was in his original order, but he clarified that with a clarification relating to preemption. Since then, since that preemption clarification, the mayors of Boston and Cambridge countered and said they have the authority to shut down job sites to keep, and it's gone back and forth. So basically what you want to do at this point in time is continue to watch and be advised of all communications relating to Boston and their governments. I'm sorry, Massachusetts and their governments, both locally and statewide, to see how that continues to work through. I will tell you that from a legal precedent issue, there's arguments on both sides, which I know that doesn't help you very much, but what it does do is creates ambiguities on the part of the government, which means that you have arguments to make if you do continue to work in Massachusetts. However, I would not recommend that if you or your employees are pulled over by the police or stopped at a job site by the police and told to shut it down, I would not take that time to argue preemption. So we are recommending that if you are shut down by the police at that time, that you shut down and then provide an immediate notice of that shutdown properly within your contract with the owner of that project, so that they understand that you have been physically shut down by authorities. One of the things that was brought up by one of the questions and answers that Jennifer alluded to was, is Massachusetts still generally designating construction as an essential activity as they were? Well, this was one of the corrections or changes, I shouldn't say corrections, because up until that point it was correct. But yesterday afternoon, Massachusetts changed their website definition of construction and what is deemed essential activity. So prior to yesterday afternoon, Massachusetts has classified construction as this: nice and simple and very general. Construction workers who support the construction operation, inspection, and maintenance of construction sites and construction projects, including housing and construction, are exempt. Those, and what I mean by exempt, are exempt from the shelter in place. They can continue to work. Very simple, very broad, and which that's the reason why that was the state order. That's the reason why Boston and Cambridge had such a problem with it, because theirs was very restrictive. But the state order was very broad, and Governor Baker basically came out and said, broad for a reason, and we're preempting it. We want construction projects to continue. Out of the blue, yesterday, that simple, clear, concise, general definition got changed to this. That is the new Massachusetts classification of construction as an essential activity. I am not going to attempt to read that to you or interpret your project unless you want to call me, and I'd be happy to then give you my interpretation or opinion on whether your specific project falls within all of those parameters. It is still, there's still a lot of ability there within these definitions to perform construction projects. But I will tell you that there are certain projects that are now going to be, in my interpretation of this, not considered an essential activity, where under the prior, more general definition, they would have been. You're going to have to read through this, and on a project by project basis, make a determination of whether that project falls within this. Again, I'd be happy to help you, make that determination if you want to give me a call. But the fact of the matter is, there's no way for me to give you a general assessment of this other than to say it is now very specific. It's going to be very difficult if you're building, say, a Dick's Sporting Goods to fall under the essential activity as defined with this new definition, where you would have fallen within the exemption definition prior. This one is a much more restrictive, but still allows quite a bit. You're just going to have to look to make sure that yours can be interpreted as falling within this. Jennifer, I see that you might have a question.
Just a couple things. I just wanted to let people know that yes, you will be getting a copy of this PowerPoint, and this webinar is being recorded, and we'll get that posted on the website afterwards. I did have another question, if there was suggested language for the cards.
Suggested language for the cards. Really, it's to just make sure that you explain who your employee works for, what the services or businesses of that organization, and why that that employee and business is exempt under the order. It should just list those things. His name, that he's an employee of this company services are this, and those services are essential under the order in this spot. So it's not really a form card that anybody can stick in their pocket. It's a form card that's appropriate specifically to your organization's employees. And if you want, just give me a buzz and I'll help you with the language on it. I'm not talking about for a fee. I can just tell you what, if I was your company, but that is a company specific card, not a form card. So now we get into, okay, we're in this climate, and it's we're in unprecedented and uncharted waters here, as we all know. So what are the sort of new best practices in new business from a business standpoint? And those new best practices are really going to be some things that you probably understood before, but now really have to think a lot more about. The first one is know that you can now expect delays and associated cost impacts. So understand that on many projects you may not want to expect delays, but you know that they may occur. Well, I don't think you should be looking at them as may occur anymore. I think you need to understand that there are going to be delays on those projects, and there are going to be associated cost impacts. And now you have to assess things like the degree of the project's reliance on both imported and domestic materials and equipment. You have to look at what types of materials and what types of equipment are being brought in for that project, whether or not they are going to be more likely than not delayed because of where they're coming from, what they are. Again, you're going to have to, when you look at delays, if they're coming from outside of this country, what's happening in that other country. If they're coming from outside of that state of the project, you have to understand what that state's governmental orders are and whether that supplier or distributor is able to perform its work, whether or not certain materials that are coming in from outside of this country may be quarantined. So lots of different things to have to assess when you're now looking at a project that you may not have otherwise paid much attention to other than just lead times. So now you're going to have to look at all of those and make some assessments relating to them. You're going to have to review your contracts and purchase orders like you've never done before. And I don't mean to, that's not a slight that you didn't look at your contracts or purchase orders before. I'm just saying you're now going to have to look at them in a detail that you haven't previously, or probably haven't previously, and specifically on how delays and material price increases are handled. Because this is going to be a significant component to how you make it through a project. And you're going to have to make some determinations. And I put down a question here that is a delay in the delivery of materials caused by quarantine constitute a force majeure event. Now, and we're going to get into force majeure in very much in detail here. But I will tell you the one thing that I have heard too many times lately is, well, that's a force majeure. Maybe, could be, but it may not be. And so too many people right now are relying on, well, that's force majeure. One is that you are going to have to determine whether you need to seek a change order or provide a written notice of a possible claim under force majeure or under some, any other delay provision, and whether or not that notice was provided properly. And we're really going to get into notice because that's something that has, I think, been woefully utilized so far and incorrectly utilized so far in this climate. And so we're really talking about right now an issue of what contract provisions you're going to have to look at, how those are going to have to be looked at, timing, et cetera. So when you go through your contracts, you're going to have to go through them in a much, much different way. And you're going to probably have to be in much more communication with your counsel than you ever were before, as much as that may make you sick to your stomach. I'm just joking. Hopefully you like your counsel. You're also going to have to look at some other things when you're determining whether a notice is going to be provided or a change order is going to be submitted, related to whether or not there's a schedule or cost impact analysis that's going to be required. Because we're talking about delays, we may be talking about some sort of schedule or cost impact analysis. What type of record retention is going to be required to go along with that? And obviously, when in doubt, send a timely contractual notice and diligently keep records. We're going to be going through specifically notice in just a bit. Jennifer, do you have something?
Yep, I've got a question here. I'm looking ahead for contracts that I signed today for jobs that start, say, in 9 months. If we see a job start, then get delayed from a resurge of COVID-19, does that constitute a force majeure or not? Because COVID-19 was already something we were aware of.
Yeah, it's an absolutely excellent question, and the fact that force majeure is normally utilized to cover unforeseeable issues or unforeseeable circumstances. And since COVID-19 is now something that we're all unfortunately very fully aware of, there's a real question as to whether force majeure would cover that. What we are suggesting and recommending for all contracts going forward is that COVID-19 actually has its own specific provision in how COVID-19 interruptions and delays will be handled on a project site. To me, that's critical at this point. It should always be separate. We've been drafting those constantly for our contracts for our clients because of the fact that we are not going to sit back and assume that a force majeure clause would now cover that, because it is now known. I will tell you that because coronaviruses themselves are well known in our society now, and there's unfortunately the deep dark secret and that nobody really wants to talk about is the fact that this could come back. It could come back in the fall. It could come back next year. And if we still don't have any type of vaccination for it or cure for it, we may be in this same situation again. And nobody wants to be there. Nobody wants to think about it, but we certainly want to be prepared for it from a contractual standpoint. So we need to be putting a coronavirus or COVID-19 provision within our contracts so that you are covered not only for its present state, but if it returns to our society, because it's going to be difficult to say that we did not, that it was an unforeseen circumstance. So great question. And you're going to see that there was a slide on that, but we're going to be, we'll pass it over as we get to it. I'd rather take things as the questions come up, and please, by all means, do that. I think it's much more interesting as we proceed forward. The next thing is do not assume that the owner will be equitably adjust your contract, both time and sum. Unfortunately, we have seen some really unfortunate circumstances so far in how owners have reacted. One thing you can always count on is that by human nature, when people's backs are up against the wall, they do things in a very protective manner. Unfortunately, that's human nature, and as an attorney, I've been dealing with that for almost 30 years. The fact of the matter is, here we have a pandemic that many owners are really concerned whether or not that they can keep their businesses going. And so as a result of that, they are taking some interesting positions. We, as you probably know, I do my work all over the country, not just here in New England. Well, I have a project that's, actually I have numerous projects out in California. One of them in San Mateo County. San Mateo County has put out a shelter-in-place order that is incredibly restrictive. And we were forced to shut down that project. My contractor was forced to shut that project down. When they did, the owner immediately sent out an order saying, a notice saying that they interpreted that order very differently, and that they believe that the contractor should continue to work, and that if the contractor shuts down the project based on its interpretation of the county's order, then they will hold the contractor responsible for all the delays and damages and costs associated. And so it's a sort of a dog-eat-dog world right now, especially when it comes to owners. And so the fact of the matter is, we need to be very diligent about how we look at the delays and delay costs, and don't just assume that there will be an equitable adjustment on behalf of the owner. Make sure you track your costs. Any costs following the CDC or governmental guidelines or requirements that arise out of that, by following them, this is how much it costs you. Track those costs, because that should be part of a claim in the end. Any additional costs that you will require to undertake relating to those CDC or governmental guidelines. Also, distinguish subcontractor and supplier issues by cost codes. Take a look at your long lead items, as we discussed a little bit earlier, because what you were already looking at as a long lead probably just got longer. And again, talk to those companies in those areas, find out where they are, whether they have been shut down, whether they're working, whether their delivery and transportation companies have been shut down, or somehow interrupted, unable to get through certain states. You need to look through all of that to figure out whether those long lead items are now going to take much longer, and therefore throw off the scheduling. And then finally, look at the path forward after shutdown, because even once we get through all of this, obviously while we're in the midst of all of this, and especially while projects are shut down, we're able to sort of basically strategize a little bit better because we have the time. Once we're out of this shutdown, hopefully once in a few more weeks, I'm being very optimistic here, we are past this virus. We can get back to work, but once we get back to work, it's going to be frenetic, and everybody knows that. And so we should be looking now at how to schedule those things, what's going to happen from a labor shortage, what's going to happen from a delivery shortage, and assess the risk of both material procurement, but also financial stability. Be looking at not just how you're going to perform on a project, or how you're going to revise that schedule and move forward, but also what's the financial viability that you're going to be paid for the services and the performance you're giving. Look at the owner's financial stability as they're coming out of this. I know that there are a lot of owners who have shuttered doors across the country, who have shut down projects with a very uneasy feeling to contractors as to whether they're going to be opening them back up. And even if they open them back up, once the shelter-in-place orders have been lifted, whether or not they are going to have the money to pay future pay apps. So look at the financial stability, use the articles in your contracts that allow you to, given these types of circumstances, to ask for the financial standing within that, where they're lending, where their amounts are coming from, to ensure that the amounts are still there to be able to pay you. Look at your subs or your sub-subs or your suppliers' financial stability to ensure that you're going to be able to get those items that you need, or you're going to be able to get the work that you need on that project. So these are all issues that you need to be looking at. Clearly, those companies that are in better financial positions are going to be able to be available in a more robust way. Keep records relating to paid sick leave or extended family and medical leave for tax credit under the IRS. Keep your payroll records, medical documentation, orders of quarantine, family leave. All of those are going to be important in varying ways, because we're going to get a little while later, we're going to get into the CARE Act, which all of you, if I say the word CARE Act, your ears should go up. We're talking about free money. And I'm not joking. I don't say that very often. I feel like somebody on a game show right now, or on some cable commercial talking about free money, but we are. This is an unprecedented act that has been provided to you under the CARE Act. And if you're not taking advantage of it, you are really losing out. So we're going to talk about that in a little while, but keep these records, because these are going to be important for that as well. Business interruption insurance. We're going to be talking about a little bit about the insurance. I don't pretend to be an insurance expert, but we are going to be talking about insurance as well. So then we get into best practices on the job sites relating to health, and we've been talking about sort of best practices from a business standpoint. Best practices from a health standpoint are pretty reasonable. First off, take personal responsibility. Encourage self-reporting of any symptoms on the site. Make sure that there's a social distancing, no large groups, no handshaking, etc. that goes on. Make sure that you're communicating the CDC recommendations relating to job site posters, etc. Some of the on-site practices that we've seen, not just in, not that are just reasonable, but we've also seen in some state guidelines relating to questioning employees about possible COVID-19. Be very careful there. You can question them. It may lead to record keeping, and if you do that, it also may lead to some potential liability exposure if you are making a practice out of record keeping relating to questioning employees about their possible COVID-19 symptoms, and then you stop doing it, or you fail to do that on a couple who end up having those symptoms and contract COVID-19, and then either pass it on or cause delays on the job site. So you got to be very careful there. Require washing of hands and set up washing stations. Make sure that they're using soap and hand sanitizers, alcohol-based hand sanitizers. Minimize the tool and equipment sharing. Obviously, the more tools and equipment that are shared, the easier the virus is to pass around. Then we have this last one, possible implementation of a daily temperature check. Remember that we have HIPAA issues as we get into that from a personal confidentiality standpoint. And I will say that Massachusetts, if your workers are in an enclosed building, Massachusetts guideline, which is really a mandate, requires implementation of daily temperature checks by somebody certified in the health field relating to temperature checks. You guys are in the pits. I don't know if that's going on the sites or not. I have not heard that it was, but that is required under the Mass guideline. Jennifer?
Sure. So we have a question here. I've been seeing conflicting information about obtaining medical documentation. Many are saying not to request doctor notes because the doctors are far too busy to be bothered with that. What are you seeing on that front for proof of needing sick leave?
I will tell you that we have not recommended requiring doctor's notes for that. If somebody is self-reporting that they have symptoms of COVID-19, then we are recommending that they be allowed to go on sick leave. That there is no, because of the issue of not just the personal confidentiality or the hospitals being overworked. Well, part of it is the doctors and hospitals being overworked, but we need to keep these people off the sites from continuing the spread of the virus. Be aware of OSHA guidelines, be aware of state guidelines, very, very different state guidelines, guys. You gotta be aware here. Massachusetts has created a mandate, and they title their guideline as a guideline, but then they immediately state within the guideline that it must be followed on every construction site. Once you use those terms, it's no longer a guideline, it is a mandate. And that means it does create potential exposure for you if you do not follow those quote unquote guidelines. So be very, very aware of them. Massachusetts guideline is extremely strict. It talks about the fact that it has a self-reporting requirement that really isn't a self-reporting. You need to discuss with the employee whether or not they are showing symptoms. Those symptoms include even a sore throat, which the CDC has now said is not potentially one of the symptoms of COVID-19, but you have to discuss that with them. You have to discuss whether they have been in any contact with an individual who has been diagnosed as having COVID-19 or has provided health care to any COVID-19, et cetera. You have to ask or you have to provide the employee with that daily temperature check if they are working inside. It's a very difficult state guideline. I highly recommend that you review it and review it closely if you're doing projects in Massachusetts, because it is a mandate, it is not a guideline. In New Hampshire, the only agency thus far that has provided a guideline, like I said, it hasn't truly been provided yet, although I assume it will be by this morning, is the New Hampshire Department of Transportation. And they have gone in the way of, they actually started with the mask guideline. And then we were able to discuss the problems and the exposure that the mask guideline created. And they agreed to remove the mandate to it. It is now just a recommendation from the New Hampshire Department of Transportation. They ask that you use your best efforts to follow the guidelines, but they state that it is advisory only. The guidelines also remove most of what is in the New Hampshire, the mask guideline, including the temperature checks, and really use more common sense than anything as they go through their guideline. And again, here is sort of some of the issues under, or not issues, some of the guidelines under the New Hampshire DOT's program. Again, there is a self-reporting, but it's a self-reporting basically to one's self, which is what self-reporting is. That if they have a fever over 100.3 degrees, a cough, or trouble breathing, we removed sore throat, they should stay at home. If they have had close contact with an individual diagnosed with COVID-19, they should stay at home. If they've been asked to self-isolate or quarantine by a doctor, they should stay at home. General on-the-job recommendations are really those that you would think are pretty reasonable: washing hands, field offices locked down to authorized personnel only, cleaning and decontamination procedures. And I won't go through all of these. I think the PowerPoint presentation will be available to you. But there's the guidelines are pretty reasonable as far as what they ask you to do on your job sites. And it's something that I think that most companies can probably adopt as their policies, although each company will have to look at this to ensure that they can on a project by project basis potentially. So then we get into, okay, we've done all those things. We have used our best practices, both business and health. And we've gotten to the point now where we understand, as we started with under best practices for business, that there are going to be delays. And there's going to be anticipated cost increases. And so what do we do here from a perspective of protecting oneself from these delay claims? Because we have seen it all over, unfortunately. I have been back. I had at the beginning of the month. I'm glad to say it's now been more than 14 days since I've been back. But I had a whirlwind tour of speaking at the AGC National Convention, and then the Modular Building Institute's annual convention called the World of Modular, and also the Fuse Alliance contractor group out in California, all in a 2-week period at the beginning of this month. And what we were, where we were then is in a different place as we are now. And I will tell you, ever since I've been back, I have been working basically 24/7 on every imaginable issue that we could think of relating to COVID-19 for our clients. It has been the hardest and most difficult period of my professional career, because everything is obviously in an emergency situation, and we have been dealing with each accordingly. So the fact of the matter is, we now know there are going to be delays, and we have dealt with them in every imaginable way, from city orders to county orders to state orders, shutting down projects, to owners shutting down projects on their own, to projects being stopped or delayed due to positive testing on site, to subcontractors or suppliers unable or unwilling to show up to a site. We have dealt with it all. And we are seeing these delay claims. So the question is, how do we handle delay claims, and how do we handle anticipatory delay claims? And I'm going to stop for a second because, Jennifer, I saw that you came on for a minute. Do you have a question for me? Maybe not. So I will go on. So I talked a little bit earlier about the fact that delays caused by force majeure can lead to extensions of time and additional compensation. And everybody has been jumping at, this is a force majeure. Every phone call I get, my contractor clients say to me, I assume this is covered under force majeure. And it very well may. The issue really is, the key is, it's in the contract definition. And so really the term force majeure is misused and can be misrelied on because of the fact that you need to look at your contract for force majeure. Not everything is covered under force majeure. It is not a catch-all provision. And so the first thing you need to look at is, does the force majeure clause in your contract specifically reference epidemics or pandemics? And I will tell you that few do. Few force majeure clauses, the same clause that we're all saying, oh yeah, use force majeure, it's definitely under force majeure. Few of those clauses actually reference epidemics or pandemics. And so it's one of those issues of, is this really covered under force majeure? Are labor shortages covered under force majeure? Because you're certainly going to run into labor shortages even once we are able to get back to our job sites. And I know many of you are probably going, well, we should have been using that already. There was labor shortages. Those weren't under a force majeure, unfortunately. But is force majeure limited to unforeseeable events? And this is something that was very astutely brought up earlier, one of the questions. And the question is COVID-19 an unforeseeable event? And The issue is a question. None of these, by the way, I would love to sit here and give you black and white definitive answers on every one of these questions. Unfortunately, as you might understand and know, we are in unprecedented times and we haven't dealt with pandemics previously, not unless you've been around for a few hundred years. So the fact of the matter is we don't know whether COVID-19 will be looked at by the courts or arbitrators as an unforeseeable event because of the fact that this country knew that there was an epidemic and potentially a pandemic going on that was stretching across the world long before we actually reacted to it. That's not a political comment, by the way. It is merely just a fact that the U.S. was running pretty business as usual, even while many parts of the world were under a pandemic that had not been classified yet, by the way, as a pandemic. And that would certainly be the argument here, is that COVID-19 really wasn't classified as a pandemic and therefore reaching the US. It wasn't an epidemic within the US and it wasn't a pandemic until more recently, and we'll talk about that. So the state law really is where we need to go first with any type of force majeure interpretation, because that's where the legal interpretation starts. What is your specific state that is the ruling jurisdiction on for that project state relating to force majeure clauses? I will tell you, and this is the very interesting thing, that we have done extensive research on force majeure at this point in almost every state in the nation. And force majeure clauses across the country have been, for the most part, very restrictively defined and interpreted by courts and arbitrators. And as a result of that, we are, if you were just putting on your lawyerly hat or your professorial hat, you would say that if your contract clause does not include epidemic or pandemic in the definition of force majeure, then you may not be able to put your delays under force majeure for your claim. However, what we're all hoping is that you can put on your human hat, and that's the one the judge will be wearing, and understand that we're in unprecedented times and that a pandemic is clearly what was understood under the force majeure clauses. So in trying to interpret force majeure clauses, one, you truly are going to have to look to your individual contract, because many contracts are manuscripted, which just means they are crafted out of whole cloth and therefore personally written. And you're going to have to see the drafter, what the drafter put in there for force majeure, because you probably didn't spend a lot of time on that previously on that provision. So you're going to have to look at what the drafters put in. We can look at what is in the form contracts for force majeure. But you're still, even if you're running under these form contracts, you're going to need to look just to make sure that that provision was not in some way revised for your specific project or by that specific owner or GC or sub. So the fact of the matter is you're going to have to look at your contract's force majeure clause. So the AIA 201 clause, and Jennifer, you are back. You have a question?
Yeah, sorry about that. I got a call that I needed to take. So I have a couple of similar questions here. What about employees staying home just because they're scared? No symptoms, no children, no reason. She's using PTO, but that may not be enough. So that's question number one. And then the second question related to that is, what if an employee says that they're not comfortable going to the job site and wants to be laid off? Can they legally lay them off, or do they need to fire them if they don't show up to work?
I will tell you that, first off, we have an entire group of employment lawyers within our firm, and I would normally refer that to one of the employment lawyers, because that is really an employment law, not a construction law question. And I will, if whoever asked that question wants to email me, and my email, I believe, is at the beginning of this section. I'd be happy to pose those questions to our employment lawyers to make sure I give the right answer. But off the top of my head, I know we have dealt with many issues relating to subcontractors not showing up to the job due to fears of COVID-19 or shutting down their work due to just fears, not positive tests, positive COVID tests or anything like that. And in those cases, those subcontractors have no right to not show up to the job site, not show up to perform their work. They are under a contractual obligation unless they can show that for some reason they cannot carry it out based on one of the provisions that we're about to talk about. And I think that the same is probably true for the employee, that if they have not tested positive, personal fear in and of itself is probably not a basis for being allowed to not show up to work. But I would want to confirm that with my employment group. And so if you, I do highly recommend that you just email me and I can give you a more substantiated response to that through our employment group. My email, just in case you don't have it, it's easy. It's rciotti, RCIOTTI at Hinckley Allen. And Hinckley Allen is spelled down at the bottom of each page of this PowerPoint.com. So it's RCIOTTI at HinkleyAllen.com. Be happy then to get you a more definitive answer for those who specialize in just employment law issues. So looking at the force majeure AIA A201, the A201, if you're not familiar with it, is the AIA general conditions, which is where the majority of terms for AIA contracts are maintained. And it is where their force majeure clause is. And you can see that it says if the contractor is delayed, and this is where we're trying to get somewhat creative because it does not include specifically pandemics or epidemics. But what it does say is if they're delayed by unusual delay in delivery or other causes beyond the contractor's control, which I would certainly argue a epidemic or pandemic is a cause beyond the contractor's control to have an unusual delay in delivery. It also says delay by other causes that the contractor asserts and the architect determines justify delay. Then the contract time shall be extended by such reasonable time as the architect may determine. So there are ways to utilize the more broad language of the AIA, but it does not specifically state pandemic. But I think that we would be able to fit it under that. And I do think that we're going to hopefully see judges or arbitrators being cognizant of the present times and present climate that we're in to be able to fit it under that. So understand that that's there. However, you may have paid attention to the fact that it says then the contract time shall be extended. It did not say contract sum. And if you notice that, you're very astute because it does not allow an increase in the contract sum. It doesn't preclude it. And in fact, 8.33 states under in the AIA 201 that it does not preclude recovery of damages for delay by either party under other provisions in the contract. So you have to get your time extension through the force majeure, but if you want a contract sum increase, then you're going to have to go to a different provision within the AIAs, and we'll look at some of those as well. Now, consensus docs, which is the other leading family of construction form documents to AIA, consensus docs form 200, which is their owner GC contract. It says, if a constructor is delayed by any cause beyond the control of the constructor, it shall be entitled to an equitable extension of the contract time. And then under examples, J specifically says epidemics. So consensus docs actually did take into account epidemics and pandemics. And it also looked at adverse governmental actions, which can be specifically these shelter-in-place orders that have been put in place that shut down your projects. That would specifically go under adverse governmental actions because it's adverse to the project schedule. But if you notice, it says epidemics, not pandemics. And if that concerns you in any way, here's how to define it under that, is that epidemics are a cause to be equitably adjusted, and for time to be equitably adjusted, that is. And on March 11th, pandemic was officially declared. A pandemic is defined by the World Health Organization as an epidemic occurring worldwide or over a wide area, crossing international boundaries, and usually affecting a large number of people. So we have an epidemic or a pandemic being defined as an epidemic. And so the term epidemic being in Consensus Docs 200, you're covered, but covered for a time extension. Again, you're going to have to get your contract some increase somewhere else within the contract. So the next we look at, if you're doing government contracting, I don't know how many out there are under FAR, or the Federal Acquisition Regulations, but they also take specifically into account epidemics and actually quarantine restrictions. They say that causes beyond the control and without the fault or negligence of the contractor, and give examples including epidemics and quarantine restrictions. And then I give the site in case you're looking for that under your FAR regs. However, the one thing that you need to be aware of when you're looking at this and saying, oh, okay, good, I was under the FAR, I was doing a government contract, so I'm going to be able to put this all under there. The one thing you should be aware of, and I thought this was interesting, is here they specifically put epidemics and quarantine restrictions as examples under their delays causes. But then when you look at claims that have been asserted for influenza and epidemics, they haven't been easily granted. And in fact, what they have come down and said is that claims of excusable delay due to an influenza epidemic have to show that the epidemic was the sole cause, not merely a contributing cause of the performance delay. So there can be no other delays, no other contributing delays. It has to be the only cause. Now here, in this situation, we may be able to show that, but you just have to be aware that just because the FAR allows for epidemics within their causes for delays, it's not an easy approach. And it gets back to making sure that the damages, this gets back all the way to the beginning of what we talked about at the beginning of this, which is make sure that you are itemizing your costs and cost coding your costs relating to what you've had to do based on governmental orders, CDC orders, subcontractor issues, et cetera, that relate to COVID-19. You have to be keeping those under specific cost codes so that you can make these claims that under those issues, those were solely caused by the epidemic or pandemic. And that's not just for governmental contracting. That's also for when we're making claims relating to the delays under force majeure or other clauses. I'm going to skip the case law interpretations. If any of the attorneys on the phone want to talk to me about the case law interpretations, we certainly can, but I've got a lot to cover and I don't want to bore you with legal case law interpretations. Anybody who wants to discuss those with me on the side, just give me a call. The next thing is probably the most important critical issue that we can discuss right now, and that's notice requirements. I was most recently asked by Fuse Alliance, a group out in California, a contractors group, whether I could give them a form notice. And I've been asked that by numerous contractors, clients, and associations, whether we could provide a just general form notice that they could send out to all of their projects. Love to. I would love it if it was that easy. It would be really much easier on me, much easier on you, much more cost effective for you, and certainly much simpler. Unfortunately, that is not the case. You can't do that. If you have done it or are doing it, stop. And if you have done it, know that you want to follow that up with more specific notice requirements. The reason being is because notices under your contract have specific terms. And every notice, every contract has requirements. I shouldn't say every form contract in the vast majority of manuscripted contracts have a specific way you give notice, and it's individual to each of those contracts. And it may be individual to each of those projects because they may have changed how notice is given on that project. And what I mean by that is there are timings for notices. There are timings for different types of notices within your contract. The force majeure clause may have its own timing for a notice under force majeure. So you have to make sure that you're following that time constraint or time deadline within that clause that you're going to use for any type of delay claim. You need to understand that there may be a form to use for all notices. You need to understand that there may be requirements relating to specifying specific provisions within the contract that the notice is calling into question. You may need to understand that you can only send notices to specific individuals at your contracting party. You need to understand that there may be ways in which the notice has to be delivered. In other words, by certified mail with return receipt, or only in hand, or only electronically, and any of notices form over substance. So any type of change to that notice, if you didn't send it to the right person, if you didn't send it in the right delivery form, if you didn't do it within the time required, if you didn't do it on the right form or format, you may have waived an otherwise legitimate claim that you had, even under the force majeure clause. Even if the force majeure clause says any and all costs relating to or delays caused by pandemics or epidemics, you feel, yes, I have it. Well, if that force majeure clause also had notice requirements that you didn't follow, you didn't get it in on time, you didn't send it to the right person, you didn't send it in the right manner, you lost that claim, or may have lost that claim. There are ways that you might be able to resurrect it, but they are few and far between. It's so important to have your notice requirements properly done. And so that is why you can't just fire off an email to all of your contract projects and say, we anticipate there are going to be delays on that project. Thank you. Or even much more formal than that. My point is that you have to go to each of your contracts, read through your contracts, determine under what clauses you can claim a delay or an anticipated delay, and make sure that you hit those notice requirements under those clauses. And so it's critically important that you have your contracts reviewed, that you have your the notices prepared. I will tell you that we are literally doing that for hundreds of clients right now, and we are doing that on hundreds of, I bet we're into the thousands of contracts that we have reviewed over the last few weeks, our entire team of 30 plus construction attorneys at Hinckley. So it has been absolutely crazy on the amount of contracts we've had to review to send out specific project-specific notice requirements, and I'm sure every construction attorney is right now. That's what we're all doing. It is incredibly important because you do not want to waive your right to otherwise legitimate claims for delays and protections under those contracts relating to the delays that may be caused. So understand that that you can't just send out a general notice and feel comfortable. And in fact, when you send out that general notice, I will tell you that you're probably just leading yourself to a false sense of security because you feel like you put out the notice, you're all set, when in actuality, you may have waived that claim. So make sure you speak with somebody relating to that and make sure it's taken care of. So other areas that that you need to look at, this is under AIA 201 when you're looking at notice, timely notice, you'll see that claims for additional time and or money must provide notice as it's provided in section 15.1.3. 15.1.3 then says claims by either party under this section shall be initiated within 21 days after occurrence of the event giving rise to such claim, or within 21 days of the claimant first recognizes the conditions or the condition giving rise to the claim, whichever is later. So again, this is just a typical timing provision relating to notice. I am not saying this is what you need to follow. It's 21 days. You're going to have to look at your specific contract, but I'm just trying to give you an example here of the types of timing notices or the types of timing requirements within your contract relating to the notices. Very, very, very important. There's all sorts of other contract provisions that may be at issue that you may be able to claim under for both protection and for contract time extensions, contract time, contract sum increases. There's delay clauses or delays caused by owner or other contractors, if that's what's happened on the site, where what we've seen in some instances where projects in areas that may have otherwise been able to continue because the shelter in place, there is either not a shelter in place order or the shelter in place order allows for construction to continue. We have had situations where owners have shut down the projects, potentially due to their own financial instability at that moment or for other reasons, and they have shut down projects. That's a delay caused by the owner, and so you're going to want to look at this. These are, by the way, when I say sections here, these are just sections under the AIA contract. Obviously, you're going to have to look at yours, whether these, even if you're using an AIA contract, whether these apply to your project because they may have been revised, deleted, or there may be additional provisions added within your contract, even under an AIA that you can use. So again, these are just some of the ones that are in a form contract. Every project should be looked at, those contracts specifically. But protections of persons and property, you can look at that. We've even had issues relating to, I had an issue on a project in Sacramento, no, San Jose, I'm sorry, where we had an issue relating to a provision that was the owner stopped the project, but would not allow the contractor to continue to protect the assets, did not want to pay for that. And as a result of that, there was all sorts of notices that had to go out relating to the issue of the owner's directive not to protect, not to pay for the protection relating to the assets while the project was stopped. You need to look under construction change directives, and that's one of the things that we've been asking for owners to make, anytime there is a governmental ambiguity in whether or not we can continue with the project, we've been asking for a directive from the owner whether or not to continue with the project, so that you guys are covered under that. If you're the GC, if you're the sub, you should be asking your GC for a directive as to whether or not the project is moving forward and whether or not they are directing you to perform the work. So it's so ask for those directives. It will help you as you move forward in having that determination made by somebody else. You can potentially use suspension by owner for convenience, termination by owner for convenience, or termination by the contractor. We get into more issues as we get through those. Contract may not be the only place to look, though. We also, there's a legal doctrine called doctrine of impossibility, which is where impossibility of performance based on unforeseen events that occur after the parties enter into the contract that makes it impossible for the contract to be carried out. Here, we may certainly have some of those issues with COVID-19, but I will tell you that the second paragraph here is probably the more important one, which it says, however, performance will not be excused if the unforeseen event renders performance merely economically burdensome. In other words, the costs have dramatically increased on that project, because we are going to see some of that. That's why we're going to talk about material price escalation. And it may become dangerous or difficult to be on that project. If it's only dangerous or difficult or economically burdensome, the doctrine of impossibility becomes less useful because it's not impossible, it's just more dangerous, difficult, or economically burdensome. And therefore the doctrine of impossibility may not be utilized. We may look to governmental action, and we are looking to governmental action in many of these instances, because if a governmental action renders a party's performance impossible, impractical, or illegal, then you may be excused from performing the contractual obligations. And again, here, in many of our jurisdictions that have stopped all construction projects, or the majority of them, like of Vermont, also New York. For those of you who are performing work in New York, you may be familiar with that. In many other jurisdictions in the country that have basically shut down work, Philadelphia, Pennsylvania, many parts of California, lots of different governmental actions shutting down construction projects. This becomes a very real legal doctrine. Next is illegal acts. I will tell you that we've already utilized this, and we utilized this in the case I already referred to in San Mateo, relating to where the owner had ordered direct performance under the contract, even though the county shelter-in-place order was pretty darn clear. It was very, very specific, relating to the fact that we're not allowed to continue that project. They were ordering us to continue that project. Well, courts will not enforce a contractual provision requiring the performance of an illegal act. And it's illegal if the federal, state, or local requirements are shut down that project or do not allow construction to move forward. They do not exempt it from the shelter-in-place order. So be aware of that. Be aware that there is this illegal acts doctrine that may be able to be utilized in protecting oneself. So then we turn it over to, okay, we've talked about protections, we've talked about putting in delay clauses, we've talked about, but none of that, Ron, helps me right this second. I have cash flow issues. How am I supposed to get by paying for my workers if we are not getting paid ourselves, and if we are not working on potential projects? Here comes the federal government. And thank goodness for the federal government, a $2 trillion stimulus package. I put the number up just because it's so staggering to look at that many zeros. We're talking about 13 figures, ladies and gentlemen. We joke about, you know, 6 figures all the time. We throw it around. Is that a 6-figure, 7-figure? This is 13 figures. So now we have a $2 trillion stimulus package. And I'm thanking my children and grandchildren, although I don't have grandchildren at this moment, and hopefully won't for another few years. But I am thanking them all because this is going to be on their backs, and I don't really understand how our country is actually going to pay for this program. But that's a whole different story. It's out there. We have a $2 trillion stimulus package that was just put into place. As many of you may know, under the CARE Act, under Coronavirus Aid, Relief, and Economic Security Act, in case you were wondering what CARE stands for, we have the SBA Paycheck Protection Forgivable Loan Program, which is really a government loan and grant program. Everybody who wasn't listening up to this point, who may have been doing other things, you may have been cleaning your room, understand that you may be home, you may be at your office, or you may be in your home office doing a lot of other work while you listen to me, this sort of little Ron in the bubble or Ron in the box presentation. Now listen, because we are talking about money that you should be looking for, that you should be getting. But before we get there, I'm going to leave you standing there and ask Jennifer, because I think Jennifer has a question for me.
Sure. It's regarding governmental action. Would that protect a Vermont contractor with New Hampshire contract obligations they're unable to perform? And also just wanted to let folks know, as an aside, I'm going to need to skip off the call here. And I'm going to ask if you could send, Sherry does have access to the questions. I'm going to unmute Sherry. And she should have access to the chats. If for some reason we're not able to get to the questions, we'll make sure that we send those on to Ron and he will be able to respond. And again, this event is being recorded, and we'll make sure that we get that to you. So I think that we're all set. Ron, you all set with that question?
I am. Thank you very much, Jennifer.
Great. Thanks, everyone.
That's a very interesting question that you ask, and good luck with everything, Jennifer. Thank you. It's a really interesting question relating to the Vermont company doing work in New Hampshire, because New Hampshire allows that work to be done, but Vermont does not allow you to carry out that work as a contractor in Vermont. As a result of that, I would think you would be able to take advantage of the governmental doctrine. But I would tell you that it is not as clean, obviously, and you probably already recognize that or you wouldn't ask the question, as if you were doing the work in Vermont, which would have shut down that project already. But because you can't get to it due to a governmental act, you can't carry out your contract. And so I would absolutely expect that that governmental doctrine would come into play. And I would think that there was probably other provisions under your contract that would also come into play if you review your contract or have it reviewed by a construction attorney. Next, I will tell you, so getting back into the CARE Act, which is so critical right now. I will tell you, when this came out the other day, I sent out to many of my clients this opportunity. And yesterday I had 9 different clients from 6 different states, conference calls discussing specifically this, along with probably about, and I'm not joking when I say this, about 100 different emails from different construction clients throughout New England and other parts, ask me questions relating to the CARE Act. Everybody wants to understand the CARE Act. Everybody should understand the CARE Act, and everybody should take advantage of the CARE Act. It's available to companies with 500 or fewer employees, which is going to include a lot of the companies I would assume that are on this call. And it is, which you should recognize as a substantial change from the SBA, because this is an SBA program, that it is a significant change from the SBA definition of a small business. But they have allowed that under this program, that companies with 500 or fewer employees can take advantage of this. Now it does, when we're counting the 500, it does take into account affiliate companies. Excuse me, so we would have to look at how those companies are formed and presented under your umbrella. But please understand that it would include those companies when counting the number of employees. To determine what you are entitled to under the program, it's actually pretty easy. You look back at your 2019 payroll, your annual payroll, and you basically divide it by 12. It's your monthly payroll during 2019, and you multiply it by 2.5 times. Probably the most significant issue relating to it is that anybody that was paid over $100,000 on your payroll, you have to reduce them to a cap at $100,000 when you're figuring out your monthly payroll. So if you had, let's say, 2 employees, one was paid $150,000 and one was paid $50,000, that annual salary, the one that would, if you were just looking at it from an annual standpoint, 150 and 50, 200,000. No, under this situation, you would have to reduce the person that was at 150 to 100. And so your annual salary would be 150 total between the 150 person and the 50 person. So I hope that wasn't too confusing, but you have to cap everybody at 100 if they're over 100,000 when figuring out your monthly payroll. It does not include bonuses, so you can't include bonuses within that monthly payroll. and then you multiply it by 2.5 times. And so if your monthly payroll is, let's say, $500,000, you multiply that by 2.5 times, and you come out with 1.25 million, I believe, if I did that correctly in my head just now. And so now you are entitled to that amount from a loan from the government. Now, many of you may be saying, well, I don't want a loan. The last thing I need is more money to pay back. Well, that's the wonderful part about this, is that first off, there are other positives, which is that there's no collateral or personal guarantees required, and that there are no fees from the government or lenders, as is normally the case. There's no tax implications for you getting this money, which is nice. No income tax, I should say. And so once you receive this money, here's the crux. Here's the major part of this. Okay, you just got a $1.25 million loan from the government. They will forgive any portion of that loan if the company keeps its employees and uses that money over the next 8-week period on certain areas. And what I mean forgive that loan is it becomes a grant. It becomes free money for you. You just got $1.25 million free. And here's how it works. You can't reduce your FTEs, your full-time employees, or there will be a percentage reduction. So if you, let's say you had 100 employees and you laid off 50%, and now that 1.25 million that you may have been able to get a full reduction, a full complete forgiveness on, you just reduced it by 50%. You can now only get 750,000 in forgiveness because of the fact that you laid off 50% of your employees. There is also a weighing relating to compensation reduction. You can't lay off 50% of your employees, increase everybody's salary by 100%, and therefore get to that same level of compensation that you were paying previously, and therefore get 100% forgiveness. Sorry, they covered that. There is a weighing between both the percentage of FTE reduction and also the compensation reduction during that time. So understand how it works. But it is very easy if you keep your guys on staff, you continue to pay their salaries, and over the next 8 weeks, you use that 1.25 million to pay payroll, which has to be at least 75% of the total amount that you use during that 8 weeks, which can include wages, health benefits, even state taxes, but not federal taxes, rent, utilities, mortgage interest payments on other debts. All of the money you use in that 8-week period in these buckets makes your loan forgiveness complete. Anything you use. So if you use all 1.25 million, congratulations, you don't have to pay back a dime if you use that 1.25 million in the appropriate buckets under the CARE Act. And so it is literally a free grant of up to that amount. And again, I'm just using 1.25 million because that was my example. It's whatever your average 2019 payroll is, with a cap on those that are making over $100,000 at 100,000, multiplied by 2.5 times. That's your loan amount that you're allowed. For that amount that you don't use during that 8-week time, if there is $200,000 of it that you weren't able to utilize during that 8-week time, you do have to pay that much back, that amount back. And you have up to 6 months to defer the remainder of that loan, the payback on that loan. And then this is somewhat debatable, but there's up to 10 years amortization under the Act. But I will tell you that banks are reading that a little bit differently. We talked to one bank. We've talked to many different banks at this point. One of the banks that we spoke with said that they will only be amortizing for 5 years. I don't know where they're getting the autonomy to determine what the amortization would be, but they are saying only 5 years on theirs. Most of them are using the 10-year amortization. But so it's free money if whatever amount you are able to utilize in that bucket. I thought I had seen some questions coming in, but I still see that Sherry is muted right now. Sherry, do you have any questions?
No, I don't see any questions, but
Okay.
if I'm not seeing them, try the chat again or reposting it under the Q&A.
Okay, great. Thank you very much, Sherry. Sorry for the interruption, ladies and gentlemen. So this is a program that is truly unprecedented. I've never seen the federal government handing out just millions of dollars, and this is interesting. Now, the application is now available, and when I say now available, I told you I changed this presentation last night because the state of Massachusetts updated their construction essential services or essential activities definition yesterday. Actually, it was late yesterday afternoon. Well, while I was on a phone call with a company from Milwaukee yesterday relating to the CARE Act, the application for the CARE Act came out through the SBA. And with it came some guidelines, but not the regulations yet. The regulations that are to be issued, were supposed to be issued or are supposed to be issued by the SBA within 15 days of the enactment. We have not seen them yet. And that's where it's going to give us a lot more specifics. Right now, we're going off of what was in the original CARE Act, but the SBA is going to give the actual regulations that control this program. We have not seen those yet, so I'm giving you sort of guidelines at this point, not specifics. But the application actually came out while I was on the phone talking about the CARE Act with the contractor from Milwaukee, and I was able to go through it with them, which made it much more real world. And on April 3rd is when those applications will begin being accepted. You can apply through the SBA 7A lender, through federally insured depository institutions, federally insured credit unions, the Farm Credit System institution, and other approved and enrolled lenders, basically banks. What we are seeing, and we have talked to a numerous amount of banks, is that the bigger banks are able to process these more quickly, which sort of goes against common thought because of the fact that they're a big bank. You would think lots of red tape. Incorrect. This is all electronic. There's no underwriting to it. It is just first come, first serve, and the quicker you can get it in, the better you are.
Ron, I do have a question for you.
Okay, yes, Sherry,
I'm
please.
seeing a question. The preliminary SBA application states that the costs are maxed at 100K. Your slide states salaries are maxed at 100K. I assume the preliminary SBA app is correct. This would be a huge difference between costs and salaries because costs would include benefits.
Yes. I will tell you that this was one of the areas that we discussed internally at our firm last night because of the fact that the CARE Act itself, when you read the actual act, the thousands of pages, which unfortunately some of our attorneys were required to do, it actually says for wages will be capped at 100,000. Costs are different. That is what the application says. Right now, the Treasury Department, who created the CARE Act, and the SBA, who created the application, are at odds relating to how they are coming at it. I think at this point, we need to follow what's in the application versus what's in the act, because the application is what you're actually filling out. And you want to be accurate to the application so that your application doesn't get bumped. So very good point. Very, very good point. It's like I said, so much of this is fluid because we think when they come out with the regs, they're going to actually, the regulations, some of this stuff will be clarified. And it could be that their application is incorrect and that they end up revising the application because it's inconsistent with the act. there was a couple of those areas. So we, that is one of the areas that are going to have to be continued to be looked at. But right now you should be filling out the applications as if the application itself is accurate. So I appreciate that, that correction.
Few more questions for you, Ron.
Please. Yeah.
I feel like we're a host. I'm a host here now. All
Yeah,
right.
no, I figured this would be the area most people were interested in. Yeah. Good.
All right. What happens if we laid off employees prior to applying for the loan? And does this provision only use the current people?
If you had a certain number of people during the 2019 year, and that's what they're going off of, the average FTE during 2019. And during that 8-week period that we're talking about, you lay off people, your numbers are going to be compared with that baseline number. If they're less, you're going to be reduced. It doesn't matter whether or not it was due to COVID-19. They're just going off of plain numbers. Baseline number that's in your application based on 2019 payroll, and what it is during that 8-week period that you're claiming under.
Okay, some more. We got some more.
Yeah, please.
All right.
People are listening. I like this.
Exactly. When you said free money, everybody started listening.
Blame them.
All right, next question. How do we know what portion is applied if we are not completely broke and funds may be commingled? Do we just show that we spent 1.2 million?
I'm not sure I understand that question. Can you repeat that question one more time?
Yeah.
Sorry,
How do we know what portion is applied if we are not completely broke and the funds may be commingled? Do we just show that we spent the 1.2 million?
No, you're gonna, and no, that's a very good question. I'm gonna go back to my last slide. You are not gonna be able to commingle your funds. You're gonna have to show that what was payroll, and in fact, it requires that 75% of the money that's spent over that 8-week period be for payroll. So you're going to have to specify and have records to show specifically what amount was paid towards payroll, what amount was paid towards rent, what amount was paid towards utilities. You know, the fact of the matter, you know, just like any running any business or accounting, you have to understand that there very well could be audits relating to this program. Now, how they're going to audit this program is anybody's guess, because of the fact that there's going to be literally millions of both applications, and I would think thousands of those granted these loans/grants. So how they're going to audit it, I don't know. But the fact of the matter is you're going to have to keep records to show whatever you are, representing. Just like in any tax situation, there is a somewhat of a honor system that you are accurately reflecting what you made, et cetera, when you're reporting taxes, and therefore what you need to pay under those taxes. You need to keep records just like that, so that if you are audited, just like in taxes, you can support what you represented. Here, it's the same thing. You're going to have to keep records to show whatever you reported was accurate.
Correct.
And you're going to have to keep those in those separate buckets. If you have commingling of funds, you're going to have difficulties, but you're going to have difficulties more than just improving this loan from a business standpoint. Yes.
A couple more questions for you, Ron. Next
Please.
question. Can you use employers' health benefits costs when figuring your average monthly payroll?
It is my understanding the answer to that is yes, that health benefits can be included in that. But I am not, I don't want to say that for sure. I'd have to go back and look at it again.
Okay. Next question. Using your example, if a loan grant for 1.2 million is given to a company, but that company only uses, say, 1 million in that 8-week period, is the 1 million forgiven while the remainder 200K becomes a loan with interest?
The answer is yes. The 1 million would be forgiven as long as the 1 million was used during the 8-week period for those items that are accepted under the program. Again, payroll, rent, utilities, mortgage interest payments on other debts, and we'll have to see the specifics of those once the regs come out. For the remaining 200,000, or under my example, 250,000, that would go in as a loan. There is a cap at 4% interest, and whether banks want to use something less than that, it's up to the loan institution. But they are capped at only going as high as 4%, and there is a 6-month deferment period where you don't have to pay back the loan, but it does incur interest at 4. And you can start paying it back after 6 months, and you can have up to 10 years. Again, like I said, there are some banks that feel that they are going to utilize a time period less than 10 years, but we're still trying to figure out where they find that autonomy to make that determination under the Act.
Thank you, Ron.
You bet.
Let me just make
So-
sure
so-
everything else looks like that's it for right now. If anybody has any other questions, feel free to put those on the Q&A and we will get them in.
Absolutely. Thank you, Sherry. So what it comes down to, the most important thing I can tell you here is not just to notify you of the program, but to notify you of the program and to tell you to file immediately to get those applications in. They start being accepted on April 3rd. Get them in. Have them on those desks by April 3rd. And be talking to your bank, be talking to your attorneys if you want further interpretations or assistance in it. We are assisting literally hundreds of clients right now put together their applications and to provide advice on the CARE Act. But you need to be doing this. You really, we do not see a tremendous downside to applying. The reason I'm saying have it in there April 3rd is this. It is a first come, first served basis. This is an underfunded program is the way we see it. There's $350 billion available. That may sound like a tremendous amount, but because it's available to any company, not just construction, this is to any small business with under 500 employees. There are probably millions of small businesses under 500 employees in the United States of America. I don't know the number, so I may be off, but there are a whole lot. And so when I hear 350 billion and I hear 2.5 times monthly payroll, to me, that is a significant amount more than $350 billion. And so it is going to be important to get in there and become that first in line, first come, first serve to get those funds. This is for the most part, a grant. Don't lose out. Get that money. So get your applications in, make sure you do your applications properly, make sure you've gotten the right advice, the right understanding of the applications, and get your applications in. There is no underwriting. They're not making determinations relating to whether or not you are the most needy. They're not looking at personal guarantees or anything like that. This is just show that you're under 500, show that you've made the calculations properly, and get your application in for the loan that you are entitled to. Extremely, extremely important. The next program I know not as much about, and so I'm going to go through it just very quickly, and that's the SBA Economic Injury Emergency Grant Program. I just want to make sure you're aware that it's out there. This grant provides an emergency advance of up to $10,000 to small businesses and private nonprofits harmed by COVID-19. Understand that you apply for an SBA economic injury disaster loan, or it's within days of applying for it. You must first apply for the EIDL and then request the advance. I put up the web link. The advance does not need to be repaid under any circumstance and may be used for key employees on payroll, pay for sick leave, You can meet increased production costs due to supply chain disruptions or pay business obligations, including debts, rents, and mortgage payments. Please understand that under this $2 trillion stimulus package, there's a lot of different programs that are coming out. The most significant one so far has been the CARE Act, and you should be taking advantage of that CARE Act and jump on that. But please understand that there are a lot of different programs, and don't mix up the programs. As they keep coming out, as we get a better understanding of each, at least for my clients and those on my list, and I will certainly share it with Josh. And I know Josh at the ABC has been tremendous at getting out all of the different opportunities for ABC members that are out there from governmental programs and other programs. Please keep watching ABC's website to ensure that you're getting the most up-to-date information. And feel free to contact me and watch our firm, Hinckley Allen's website for updates as well. We've been trying to get out information as quickly as possible. I think everybody has. And I will say this, I think, this industry has done a tremendous job at staying together, at making sure everybody has the right information and trying to do the right thing. I'm proud to be a part of this industry. When I say this industry, I'm talking about construction. There's also potential loss situations relating to insurance policies and issues. Understand these are out here. I'm not going to have a lot of specific answers for you in this area. One, I don't think anybody does, because it's really kind of unknown as far as how and what insurance is going to be available for some of these losses. And I don't pretend to be an insurance expert. We actually have a team of attorneys at Hinckley Allen who are insurance experts and who handle these issues. But this area is a very different area. But it deals with, employees who contract the virus, and understand, I think everybody knows you have to shut down operations, including, and you're going to have expenses due to cleaning the facility. You're going to have to clean the facility while it's shut down. And obviously you're going to have have significant costs due to the shutdown itself, aside from the cleaning costs. And understand all of the various different coverages that may cover some of the losses due to a government order. Business income coverage in issue of property damage, is contamination of the premises, property damage is inability to use the property due to a governmental order, property damage, communicable disease coverage is in some policies. You're going to have to look at that. Civil authority coverages in some policies require physical damage, some policies do not. Understand the ingress egress prevented without coronavirus of workers on the job site. Does your policy require physical impediment to ingress or egress? There's so many different things to cover under insurance. Lack of supplies, materials, equipment. Does your policy contain contingent business interruption coverage? Workers' comp insurance issues for those who contact the virus. And of course, job shutdown restart under builder's risk. The interesting thing is, obviously some of the questions to look at for policy interpretation is there a virus exclusion or extension of coverage in your policy? Is there broad form contamination exclusions in your policy? And know that right now, the government is trying to take actions in many states, which may now expand your future coverage under your policies, which is going to be very, very interesting because the insurance carriers are looking at this saying there was, some of these expansions that are being mandated by the government were never intended under the policy, and the government can't come in and just expand our coverage under the policy. So there's going to be some major battles and litigation over this. This is, you haven't heard the last on insurance coverages and policies. The last thing we're going to go over, and I'm going to go over it very quickly. I've actually done an hour and a half long presentations on material price escalation. I'm going to touch on it very quickly because we're going to see material price escalation as a result of COVID-19. Anytime it's supply and demand, anytime that we have an issue relating to the fact that there is not enough supply, we're going to, not enough supply and there's a big demand, we're going to have price escalation. And so it is what price escalation is all about. It's usually brought on by an unexpected explosion of prices. And one of those ways is pandemics. The funny thing is I put this presentation on for 3 different associations across the country last year. And one of those associations I just spoke at again. And I asked people how many people remembered my presentation from last year, and the entire audience put up their hands. And I said, didn't think it was that timely, but it turned out it was very timely because those who have material price escalation clauses in their contracts right now feel a lot more comfortable because they don't have to rely on things like force majeure, and even force majeure may not take into account material price escalation issues. And so what material price escalation clauses really do is to protect you from, if you give a bid on a project and you're bidding it because you think you can get the product at a specific dollar amount, and based on, let's say, a pandemic, the material price explodes. And now you're being held to that original price, and obviously it blows up your bid. And it may be at a time that is critical for you. Material price escalation clauses are there to protect you from that and hold a baseline price for specific materials. You can do this at the time of the bid, during the procurement phase, during the contract negotiations, which is basically, by the way, the best time to do it by including a material price escalation clause in your contract. You can do it in some ways by and with your existing contracts. It can be done through cost estimates. You basically need to account for price escalation using a cost index such as the BCI or building cost index or the construction cost index, or even the Turner cost index. I'm going to go through this pretty quickly. There are additional processes during pre-bid where you can lock in material prices with suppliers and shift the risk downstream to those suppliers. It's one of the ways you can do this versus a material price escalation clause. And in fact, it's the better one. If you can't negotiate a material price escalation clause, it's one of the ways you can still protect yourself. You can include a generous bid contingency that accounts for the potential escalation, but the fact of the matter is it's very difficult to account for material price escalations when it explodes like this. And if you put too big of a bid contingency, we all know you're not going to get the project. So the better way to do it is in a situation where you put it into your contract. You can shorten the time duration your bid is valid, but in some cases that's not possible or not allowed. So know that if there is a understanding or you're in a volatile time like you are now, purchase materials with the most volatile prices as early as possible so you can get that, so you know what that price is that you're going to pay. But obviously you have to consider the impacts of potential design changes if you're going to do that, the increased storage and handling costs that are associated with doing that. So the best opportunity to do this is through a risk, to mitigate the risk is through a material price escalation clause in your contract. In the typical lump sum contract, the contractor bears the risk, and we're trying to shift that risk from the contractor to somebody else. And basically there's 3 types there. There's arguably 4, we'll talk about the 4th, but there's 3 types of escalation clauses, a day 1 escalation clause, a threshold, and a delay escalation clause. The day 1 is easy. It's truly just you are responsible for that price from day 1, on day 1, and the owner is responsible for the price outside of that. or your upstream contracting party, I should say, is responsible for the price after that. So if you bid that price with that widget at $1 per widget, you put that in as a base price, you put an appendix with it showing that that was the base price that your bid was based on, and then any escalation in that price from that point forward is the responsibility of the owner or the upstream contractor. The threshold escalation clause is where you use a threshold. So it shares the risk by requiring the upstream party to be responsible for the price increase above a certain threshold. So if that material price baseline for that widget is $1, you can accept that if it goes up the first 5%, you will accept that. But if it goes up beyond 5%, the upstream contracting party will take that on. Again, it's to protect you from the significant price change. A delay escalation clause allows the contractor to receive an equitable adjustment if the project is delayed, or more commonly, if it's not feasible to purchase the materials for the project when you were scheduled to purchase those. There, the upstream party takes on that from a specific date, so you need to show those dates in that delay scenario. Now, understand the upstream party may not be willing to just take on this risk. And so one of the ways that we have looked to make it a more fair provision and therefore a more acceptable provision is a way to share the risk, is to share the risk and the benefit. This is that fourth type of escalation clause I talked about, which is called a mutual or bilateral clause, whereby let's use the threshold clause, which is what the Consensus Docs 200 uses, the Amendment 200. In that clause, if you have a 10%, if it rises, let's use the widget again. If that widget rises more than 10% in cost, you, the contractor, have the first 10% of that increase, and the owner or the upstream party everything above that. Same thing happens though, and this is the benefit part of it to that upstream party. If the price drops, you get the benefit of the first 10% of that drop. If it was supposed to be $1 when you bid the project and it goes down by 10 cents, it's now 90 cents, you get that first benefit as the contractor. But then anything after that, if that thing drops in half, the upstream party gets that benefit. And so that's how to make these more acceptable and allowable, so that there's a more controlled risk management for price escalation. And I will tell you, in these times of trade wars, tariffs, and now pandemics, material price escalation clauses have become almost necessary provisions to be found in a contract. Now, if you don't have it in your contract, there are other areas to look in depending on what caused the material price escalation. There may be change in law provisions. If there was changes in law that required the price change, there may be force majeure under the pandemic. If we can fit it under a force majeure clause, there may be mutual mistakes clauses that we can put it under, or commercial impracticability, which we talked about earlier, the impracticability and impossibility standards. However, just know that these are all more difficult arguments to make, a lot more difficult than just having a material price escalation clause in your contract. Know that under the form contracts, AIA does not have a material price escalation clause in it. So you need to add that and be very aware that you have all the risk as a contractor under AIA. Surprise, surprise. If you haven't worked with me before, if you have worked with me, you've heard this mantra, but if you haven't, AIA contracts are not good for contractors. Understand that. Please know that. They are not good contracts for contractors. They are very difficult contracts for contractors. They are not made for contractors. They're made by design professionals for design professionals, and they love to stuff everything down, all of the obligations and responsibilities down to the contractor without a contractor having any rights. Not great contracts. And surprise, surprise, there's no material price escalation clause. Under consensus docs 200.1, you do, as I talked about, it's a balanced threshold mutual clause. So now we have all of this being said, what are we doing for future contracts? Please make sure you understand that we're putting in COVID-19 provisions in our contracts because they are likely to be deemed to have imputed knowledge of the world's circumstances and deemed to have assumed the risk of COVID-19, as you see here. So that question that was asked at the beginning of this program was very astute, and we hit it right here. Please put COVID-19 provisions in your contracts, and coronavirus, because COVID-19 is a type of coronavirus. So make sure that coronavirus is covered. It is likely to come back. I give you an example here of a provision. Obviously have material price escalation clauses in your contract. This has been a wonderful crowd and some great questions. I want you to please understand that we are here for you. The ABC is here for you. But I want to end this presentation with a poem, because I want you to understand in this very difficult time, whoop, sorry about that. I assume you can still see my, Sherry, can you confirm that you can still see my screen? Because I want you to, at a time when it's been very difficult for contractors, I want you to understand why we all are in this industry. Sherry, can you still see my screen? Hello? Sherry?
Hey, Ron, it's Josh. I can see your video image.
Okay, you can see the video image?
Yeah, I just don't have your slides up, but we see you.
Okay. Can you see the video?
No.
Oh, okay. I'm going to stop this then for 1 second. Not sure what I did when because my screen is very different now. I'm not exactly sure what just happened. No, that's not it. I apologize for this, guys. Screen share. This is it. I think this is it. Can you see it now?
Yes, we have it.
Great. When we all are in this difficult time, I think it's important for all of us to remember why we're in this industry. And I can't think of a better, I actually met the author of this poem, who also is the one who narrates this poem. And he is the epitome of a worker, a construction worker, and he makes all of us remember why we're here.
You say the world needs ditch diggers, and that statement's true enough. But if you're saying it because you think you're better than us, then with you I've got a grudge. For we are every creed and color. We are woman and we are man. We fall into what society calls blue collar, and we are proud to wear that brand. Our hard hats are our resume. They are tattooed with stickers, timelines of who we are, where we've been, what we've built with our machines, our skills, our hands. See, everyone is built to do something, and we were built to build this world. We're doing what we were designed to do since we were just little boys and girls. Yeah, everyone's built to do something, and we were built to build this world. We're doing what we dreamt to do since we were just little boys and girls. So when you're heading down the road and see those operators cut and grade on those big machines, and those iron workers cutting, welding, shaping, tying those skeletons of steel, those laborers and those carpenters getting ready for that big pull, take that bridge you're traveling across from 3 lanes to 4. And the crane operators who will pick and pluck and place and set with precision and with ease, while their work and sometimes their office sways upon the breeze. The linemen in their bucket trucks, and the excavators out putting in the pipe, the plumbers who get the good stuff in and the bad stuff out, and the HVAC techs who give you the comfort in your office and in your house. From the high lines to the pipelines, we build, repair, and service the infrastructure that fuels your life. From the Golden Gate to the Brooklyn Bridge, we have built the monuments and the buildings that make up the silhouette of the skyline in the city which you live. From the highways to the byways, the runways to the driveways, these things we build, well, they'll still stand long after we are gone. A testament to our passion, do our part, keep this country moving on. And some of us, well, we're born into it. It's synonymous with our family name. It's bred into us through generations, and it pulses through our veins. Others, well, we are those kids that played with Lincoln logs and Tonka trucks and all the light toys, and we grew to be men. We grew to be women. We knew construction wasn't just for boys. Some earned their skill when for this country they did proudly serve. To them I say no higher respect could one truly earn. And the reason why we do what we do, well, it is simple to us, but it is too complex for passerbys to figure. So I ask them to ask themselves, how does it all get done? How does the world get bigger? And the irony is, the answer is, it rests on the shoulders of all of them ditch diggers.
With that, I guess I will bring this, my presentation to a close. I got to tell you, I am honored to be a part of this industry. I know that you guys each are. We are going through a very difficult time right now, but our country has persevered through every test. We've persevered through this. We're just going to do it right. The ABC has been here to help you do it right. And we'll continue to be there for you, presenting presentations like this and others. And I am also here for you. If you have any questions, please, by all means, again, it's Ron Ciotti at Hinckley Allen. Give me a call. Easiest way to get me these days is on the cell, 603-491-0442, or rciotti, RCIOTTI, at hinkleyallen.com. And together we're going to get through this all. Thank you.
This is Josh. Just Ron, thank you again for your great presentation today. And just a quick reminder, everybody, that we are recording this and we will make that available for our members later. And again, thank you, Ron. Thank you, everybody. Be safe and be healthy out there.
Thank you.